Thank you very much, Senator Brandis, for a superb start to today's conference. I'd like to introduce the second speaker, the Honourable Graham Perrett, MP, who is the ALP member for the federal seat of Moreton since 2007. He is also the chair of the House of Representatives Standing Committee on Social Policy and Legal Affairs, and a member of the Committee on Aboriginal and Torres Strait Islander Affairs. After a period as a school teacher, Mr Perrett graduated from the University of Queensland with a Bachelor of Arts with Honours in 1993 and a Bachelor of Laws from QUT in 1999. He was admitted as a solicitor and worked as an organiser with the Queensland Independent Education Union, and then as a senior policy advisor for Queensland Ministers Stephen Robertson and Jeff Wilson. He published his first novel, The 12th Fish, in 2008, and in October last year he threatened to resign and force a by-election if Julia Gillard was removed as Prime Minister. So I welcome a man of principle, Mr Graham Perrett. Thank you.
Good morning, ladies and gentlemen, and could I firstly acknowledge the traditional owners and thank them for their continuing stewardship. And thank you for that introduction, Professor Carney. I didn't think I was honourable, but I defer to Senator Brandis on that. I thought as a backbencher that I was not honourable.
With a small H.
Yeah, the small always with the small H, always with the small H. I'd hate to mislead any of the students here. But I appreciate the opportunity to speak today on the Australian Parliament and the rule of law, and in particular some of the recent steps that parliamentarians have been taking to strengthen this fundamental element of governance in Australia. I acknowledge today's keynote speaker, the former Justice of the Federal Court of Australia, David Jackson. Senator Brandis, thank you for your relatively kind words. And all other distinguished guests. In fact, as a Member of Parliament representing a marginal seat, could I also acknowledge the non-distinguished guests that are here today, particularly if you live in the electorate of Moreton. My thanks to the kind invitation from the Rule of Law Institute and all of the organisations involved in today's event, the Centre for Public International and Comparative Law, UQ School of Law, the Queensland Bar Association and anybody else. I first met the Rule of Law Institute of Australia in my capacity as chair of the House of Representatives Legal and Constitutional Affairs Committee, where I thought some of my questions or my cross might have been a little bit over-enthusiastic, but apparently not, as I'm here today, invited to speak today for my sins. Although I did notice that you put me on after Mr Brandis. Perhaps if I'd been a bit more enthusiastic, you might have put me on before him and then he could have made further comment. But at that first meeting in Canberra, my Legal and Constitutional Affairs Committee was exploring aspects of the rule of law as it applied to Australians via the Crimes Legislation Amendment Powers and Offences Bill, which was quite an interesting piece of legislation, and we actually ended off going to inspect the Australian Federal Police DNA testing laboratories in Canberra. And earlier in the day we looked at, listened to the bureaucrats and people offer opinions on how this impacted on the rule of law. And theoretically it permitted practitioners to provide oversight to the testing of their clients, yet practically it did not. So it's interesting to have that, that praxis, I guess, that between the theory and practically what occurs. Yet another example, a small piece of legislation that not many of you will be aware of, where those same questions are asked about the eternal tension between the rules and the ruled. Are the rules of law fixed principles and beliefs that we as lawyers and society in general can rely upon, or is there a dynamic process open to change, adaptation and development? As a legal practitioner and politician from the left, I have some deeply held beliefs about what the rule of law is, and I hold sacrosanct that important role that it plays in society. And as practitioners, I know that you are probably here today because you feel much the same. And so I'm sure in future years we'll be booking out the bigger ballroom as people come to these conferences. We rely upon the rule of law for certainty, predictability and equality. And in our stable nation here between the Southern Cross, where we change governments with ballots, not bullets, with real polls, not opinion polls, where governments change due to sound votes, not sound bites, we can rely on the rule of law unwaveringly. Not unquestionably, but unwaveringly. Even if your last name is Hicks, or Hanif, or Assange, or even Thompson. So yes, folks, I declare that I firmly believe that justice is owed to you, even if your name is Jeff Thompson, or Hector Thompson, or even the Thompson twins, and even if it's Craig Thompson. Now, I got elected at the same time as Craig Thompson. He's a mate of mine, and as Professor Carney indicated, I made some statements last year that got me a lot of media attention. And I actually made the comment that my electorate did not like the idea of just changing leaders overnight. And I said to them that I'd try to keep faith with my electorate and go through the electoral process. And I got a lot of media attention over it. And I actually got a text from Craig Thompson. And I thought, gee, I know I'm in trouble when Tomo's sending me a text to say I'm thinking of you. It was a sure sign that it was a tough time. So, despite political expediency that ebbs and flows, I still believe that the rule of law is a linchpin of modern society, all civilisations in fact. And yet, this has been challenged in our recent past. For example, that written in stone notion of double jeopardy has been successfully, so shall we say, redefined in recent times. The fundamental principle that you can only be tried once by the state for a crime has been usurped, or at least severely tinkered with anyway. How do we as lawyers, as citizens, as politicians, process this change? It's a question I'd put to Andrew Bowe if I had time. I've got to run off after this. Is it for the betterment of society, or does it shake the pillars that our laws have rested on for so long? Last night I read my son a bit more, only a few pages, of To Kill a Mockingbird by Harper Lee. It's a stop-start process because he's only 7, and we often don't get past other books about farting dogs or defecating dinosaurs. It's amazing what kids are reading nowadays. The good old days you only read about wolves eating kids and things like that. Now it's much more they always seem to engage the kids a lot more than some of the kids I read when I was a kid, I suppose. Nevertheless, the rule of law in To Kill a Mockingbird shines through as a beacon, as it does through many of our works of literature. And I mean Mockingbird works, not dogs and dinosaurs type books. But not all of our lawyers or our politicians are as finely drawn as Atticus Finch. And in this time of rapid technological and social change, we must never lose sight of what underpins the freedoms many of us take for granted. Ready access to the courts and other dispute resolution mechanisms, the ability to challenge government decisions in an independent tribunal, and the right to participate in the legislative process through your local representative, or even your senator. My wife is just about to be admitted as a solicitor. She's spent the last 22 years working in child protection, unfortunately, rarely seeing humanity at its finest. And when writing this speech, we discussed how we felt about Queensland laws, or laws generally in Australia, that sentence people now for future sex offences that they might commit. And it's quite testing when talking to someone who's about to be a servant of the court, a solicitor, who's also spent 22 years dealing with some people, as I said, not humanity's finest. I won't tell you what she said about such offenders if it involved children, but it is a telling comment on how the rule of law is forever tested and pushed and occasionally pummeled. Now, these laws that we're talking about were not plucked out of thin air. Some of the best legal minds in Queensland worked on this taxing legislation. These laws were not glib responses to stories on a current affair or Today Tonight. Our best and brightest focused on these issues and worked on what was the greatest and the good for the most. But the burden on the well-resourced state is heavy for a reason. We don't want to throw the baby out with the bathwater. In simplistic terms, the rule of law means that no one is above the law. No one. It also means that justice must be available to all, and thus it protects all. So small a definition for a concept so central to our way of life. No one is above the law, especially the government. be they progressive or conservative. Our actions must adhere to legal and moral requirements. We are a nation of checks and balances, a federation, and we believe in that separation of powers. That is something of which we should be proud. The Attorney General, the Honourable Nicola Roxon, once said, "One of the building blocks to a strong, functional democracy is a judicial and legal system that works equally well for those with few resources as for those with many." We are all very lucky here in Australia compared to numerous countries around the globe. We have a strong legal system that is constantly reassessing itself to ensure fairness and effectiveness. I think that today's panel is part of that process. We are certainly fortunate, but we must not take it for granted. This work is based on the principles of openness and transparency, accessibility and a constant focus on resolution, efficient administration, and preparing our court system for the challenges of the future. Some small steps forward have been made. Early in January, when many Queenslanders were at the beach, our new Attorney General made an announcement about human rights being brought into sharper focus in the Parliament this year and beyond. The Human Rights Parliamentary Scrutiny Act 2011 came into effect on the 4th of January and requires all new bills and disallowable legislative instruments to be accompanied by a statement of compatibility with human rights. Statements will assess compatibility against the 7 main United Nations human rights treaties to which Australia is a party. The Act also established the Parliamentary Joint Committee on Human Rights, the first Commonwealth Parliamentary Committee dedicated solely to human rights scrutiny, chaired by Harry Jenkins, the former Speaker. This committee will also serve to examine bills before Parliament to advise whether they are compliant with Australia's human rights obligations. The aim in establishing the committee is to ensure that key principles of freedom, respect, equality, dignity, and a fair go for all Australians are considered in everything the Commonwealth Parliament does. And I'm sure that even the Honourable Tony Abbott would agree that checking all new laws to see if they stack up against human rights obligations is a good thing. In January, our new Attorney General said, "This important step is part of Australia's human rights framework and will give the community confidence that their human rights are being recognised and respected in everything the Parliament does." And I'm sure that Harry Jenkins will ensure that that does occur. Good, sensible, responsible governments should always ensure that those key principles of freedom, respect, equality, dignity and a fair go for all Australians, words that should resound throughout the nation, are considered in everything the Parliament does. We do have a proud human rights record that will be further strengthened by preserving the consideration of human rights in the development of our nation's laws. Discrimination is also like kryptonite to the rule of law. Consequently, creating the position of the Age Discrimination Commissioner, for example, allows us to tackle age discrimination for both older and younger Australians in our workplaces and in the broader community. A Labor government appointed Australia's first standalone Race Discrimination Commissioner, separating the roles of Disability and Race Discrimination Commissioners. Australia is also taking tough and comprehensive action against corruption. And as a Queenslander, we know that that is the rust that never sleeps. Or maybe that should be the mistrust that never sleeps, because corruption and dishonesty and deceitfulness undermine the social institutions that we as a nation demand and deserve. Australia has a strong record in tackling corruption and is ranked amongst the least corrupt nations in the world. Nevertheless, our national anti-corruption plan will boost our efforts. We are currently taking input into how Australia can effectively address emerging risks and respond to corruption in both the public and the private sectors. In fact, public submissions to the National Anti-Corruption Plan discussion paper closed today. So if you have time in the break, feel free to log on. And while you're doing that, you might also like to complete my committee survey, which is part of the inquiry I am chairing into the marriage equality legislation. It too is closing today. Now, Senator Brandis, I know you won't be allowed to have a vote on this legislation, according to your conscience, but I think you're allowed to fill in the survey if you want, so that we are aware of your views. I'm sorry, but can I segue back from that back into corruption? Australia's first national anti-corruption plan will position Australia better to fight corruption at home and internationally. Australia is also currently undergoing a UN review of our compliance with international treaties. The Attorney-General met with experts from the USA and Turkey when they visited Australia in March, and we look forward to their constructive comments on how Australia can improve our anti-corruption regime. We are well equipped to respond to corruption threats, but we cannot be complacent. Parliament also has an important role in protecting our judicial system from interference. Sometimes, erroneously, labelled the weakest arm of government, the health of the judiciary closely reflects the health of the polity. Australia's court system is renowned for its excellence and independence, but it can only maintain these levels through eternal vigilance. Alongside the strength of its judgments, of course, must be the ability for all parties to obtain access. As the Attorney-General, the Honourable Nicola Roxon, has made very clear, our judicial and legal systems must work equally well for those with few resources as for those with many. Australia's justice system must be geared to the small one-off litigant seeking redress, as it is for our large corporations who utilise the courts as part of their everyday business. The Parliament plays its role by ensuring the legislative framework is in place to achieve this goal. For example, the Parliament is currently considering legislation establishing open and transparent ways to make complaints against federal judicial officers. And we're looking at the current contract law system as well. So, we've got a lot of work to do. We're not shying away from it, the Gillard government. As Chair of the Standing Committee on Social Policy and Legal Affairs, much of my time is dedicated to investigating specific matters of policy or government administration or performance. And it's a bipartisan committee, and it's interesting, one of the political processes, especially in that House of Representatives, is that the committee forms a life of its own. Right now, the committee is looking into the Judicial Misbehaviour and Incapacity Parliamentary Commissions Bill and the Courts Legislation Amendment Judicial Complaints Bill. And for this inquiry, we've been joined by the former Attorney-General, the Honourable Philip Ruddock. He was interested in this topic, so has asked to be a part of the committee. Terms such as separation of power and checks and balances don't seem to faze some of my parliamentary colleagues in their mission to be both investigator and prosecutor in independent investigations. I'm not a big fan of this blatant interference with independent investigations. The legal system and governments work in harmony for the good of the Australian people, but this relationship is only as strong as the respect shown to the principles of the rule of law. Interference compromises all progress made. Short-term gain on the 6 o'clock news maybe, but long-term social detriment. To foster lasting change in our justice system, this sort of meddling and interference and lack of respect must not be tolerated. The Attorney-General, Nicola Roxon, has told us to expect a lot of attention on ensuring our legal system remains sound. So looking at our federal courts and tribunals, making sure they're running efficiently. Looking at how our legal system is ready for the changing technological world, particularly in things like cybercrime, cybersecurity and copyright. Measuring our security capabilities to keep us up to speed on emerging and changing threats to our way of life. I'm truly honoured to be a member of the House of Representatives in a country where the judiciary is internationally recognised for its excellence and independence. We will continue to strive for the best with the rule of law, the cornerstone of democracy. Most importantly, I believe that human rights and protections are synonymous with the rule of law. Without such protections, we cannot guarantee that all Australians can fully participate in the economic, political and social life of our nation. The reason I joined the Labor Party is because I believe in opportunity for all, in equality for all and in justice for all. Sometimes during the tougher times, these are hard prizes to keep our eyes on, hard things to fight for, but the harder fought, the better one. Thank you.
Thank you very much, Mr. Perrott. It's great to hear two politicians who are so committed to the rule of law. At least we can gain some confidence that the importance of this area is in relatively good hands in Canberra. We have time for two questions. Would anyone like to ask either of the speakers? Professor
I have
Allen.
a question for Mr. Parrott. I understand how an elected MP needs to have legal protections and that concept of the rule of law. But why do those sort of protections carry over into other areas of law or non-law? For instance, if you knew a financial services person who'd been 3 times convicted, would you have to give him the benefit of the doubt, the same legal benefits of the doubt, a presumption of innocence, when you made your decisions about how you were going to, say, deal with your superannuation? I personally cannot see the connection between your claim that Mr. Thompson has some sort of rule of law protections in law and the simple claim that we expect more from our MPs than we do from drug barons. I just do not understand the connection you're making with Mr. Thompson.
So,
I cannot understand the connection you're
are
making.
you saying that you find it hard to believe that Mr. Thompson should have a
I believe
presumption of
in the area
innocence?
of law, when it comes to his criminal prosecution, he deserves every protection. When it comes to staying in the House, staying in the Labour Party, or staying in the Labour Party, I don't understand why Prime Minister can't say, if you want to stay in the Labour Party, then I expect you to cooperate with the police. If you don't want to stay in the Labour Party, fine, stay in Parliament, rely on all your legal protections. I do not see how the two are connected.
So you're saying he should admit guilt irrespective
no,
of...
the Prime Minister should expect more for MPs than not cooperating with the police. It won't affect his legal protections at all.
Well, I thought he had cooperated with the police. Well, my understanding is he has cooperated with the police. I mean, there's been a Victorian investigation, a New South Wales investigation. Mr. Brandis might know a little bit more about the New South Wales investigation, but I thought he had cooperated. Now, I don't know him, you know, he's not my best friend in the world or anything, but I would have thought there is an expectation that he has a right to let the investigation run its course. If you're saying he should...
At criminal law, I totally agree.
So you're saying he should resign from Parliament?
No, I'm saying that we in other areas of life, nobody's asking him to admit guilt, but...
But you are.
No.
You are.
No, you're not.
I'm sorry, you're saying he should resign from or be sacked from the Labor Party or resign from the Labor Party
Unless he's
before...
prepared to cooperate, I don't see why. I mean, people don't have a right to be, don't have an entitlement to be in the Labour Party, do they?
Of course they do.
Okay, well, I just don't see how the rule of law bears on that question at all. Can't see it.
Well, the point I was making that there is a presumption that I believe in a just system that you let the investigation run its course, and that we should not presume that he is guilty. I don't know the facts of the case.
So you would condemn Premier Campbell Newman for asking a member of his cabinet to step down?
Well,
He wasn't convicted.
certainly not publicly.
I think he made the right call, Campbell Newman.
Well, he made the call he made that was appropriate in his circumstances. You know, I admire his courage in that situation, but I'm not sure why you would connect those two particular things.
Okay, thank you, Professor Allen. I think there were several questions in that. Any other quick question?
Just a quick one to both, but Senator Brandis could lead. You mentioned, and we applaud your decision about the Administrative Review Council. Currently, the Administrative Review Council has but one reference, and it doesn't have a reporting date nor terms of reference. Do you believe it should have more specific tasks and even better resourcing than it currently has? And I'd be also interested in Mr. Perry's response to that as well.
Well, Richard, you know, at these legal conferences, I always try to avoid, as much as I can resist the temptation, scoring political points, because I think people come here to hear us speak about the issues in the conference. But it is a fact. It is not a fact that is capable of being honestly disputed. The Administrative Review Council has been treated appallingly by this government. For a while, as you would be aware, it wasn't even properly constituted because its members had not been reappointed in a timely fashion, so it was unable to function. The report to which I made reference, which is an important reference to the ARC, has been basically allowed to gather dust for 4 years. and as you rightly say, it currently has one reference. Now, I think it is implicit, well, it's not actually, it's explicit in what I said in my remarks to the conference, that in the event that I were the Attorney General, because the Ministry Review Council is an agency within the Attorney General's portfolio, I would seek to revive its activities, and particularly with an emphasis on the rule of law issues that I canvassed in my scripted remarks.
I must admit, I haven't looked at the budget. I mean, the budget's a big consideration there. I know it's been a tightening up, and it's a small organisation that has suffered. But look, obviously I'm part of the government, but I think in my entire life I've seen the benefits of decisions being open to be reviewed, because not everyone gets it right at the first time. And could I also say that no, I'll leave it at that.
Thank you. I know Mr. Perrott needs to get to the international airport as soon as possible, so can I ask you to express your appreciation for the effort they've made to come here this morning, the time they've spared, and for speaking on such an important